Hi, I'm Jeff Holman with Intellectual Strategies. We're a law firm that focuses on intellectual property for startups and technology companies. We help a lot of innovators and inventors and brands get started with their own intellectual property portfolio. I want to talk to you about patents. Patents are a very useful tool for a lot of startups and entrepreneurs because they help protect your inventions. Inventions come in a lot of different forms, but they're really anything that you make that's structural or functional. You know, it's the thing that you make, the hardware that you create, maybe it's the new shoe, sometimes it's even the design that you're using. So how does the process work? The United States Patent and Trademark Office will grant you a patent if you've satisfied a few criteria. As an example, here's a copy of a patent that we just got for a client. When you submit your patent application, you have to fulfill a few requirements. You need to first submit a description of your invention, and that's usually done in the form of what's called a specification. It's a written paragraph form description of what you've invented. To go along with that, the Patent Office asks you to submit drawings that will help them understand what the description says. And then finally, they want you to put in a very concise set of claims. The claims are the legal boundaries around your invention. If you ever have to sue anybody or enforce your patent against somebody, your claims are where it really counts. The patent process can be pretty extensive. Not only do you need to describe and show your invention and claim it, like I just mentioned, you also need to go through an entire examination process. The United States Patent and Trademark Office will do that examination with a patent examiner who has some experience in your technical field, and they'll be going back and forth with you through official office actions. The patent examination process can be pretty long. Normally, the examination process can take a year or 2 or 3 years, depending on the type of invention you've created. During the examination process, the patent examiner is going to look and make sure you've met all the requirements and formalities so that a patent can be issued and granted to you. The two criteria that are really important during the examination process are what we call novelty and non-obviousness. Novelty simply means, is your invention identical to something else that's already out there? If so, they can't give you a patent. If it's not identical, then they look at non-obviousness. And this can be a little bit tricky to understand sometimes, but non-obviousness just means, would your invention be an obvious change or variation from something else that's already out there? A lot of times you hear people say, your patent has to be at least 10% different from something else that's already out there. Well, I don't know what 10% difference would be for an invention, but there is a set of criteria that the Patent Office could look to and that we as patent attorneys can use to explain the technical and the legal differences between your new invention and the other things that are already out there that we sometimes call prior art. Once you go through that process, a patent examiner determines that your invention is novel and non-obvious and meets the other formal requirements of examination. Then they'll give you a notice of allowance. That's fantastic because that means you're going to get a patent pretty soon and it will issue. This means that you have an issued patent and you can use it in your business. You can use it to enforce against somebody else if you want to. You can license it to other people, or you can use it to protect your own products. We love working with technology companies, inventors, entrepreneurs, and startups. If that's you, let's connect. We offer a free strategy call to talk about the problems you're facing and see if we're a good fit. You can register for a call by clicking the link below, and we can't wait to chat with you.